Can attending workshops be the barrier to your dream job? What if 100 hours of training stood between you and your professional license? Find out how one psychologist's battle reached the Supreme Court. Sobrejuanite-FLORES versus Commissioners Pilando Jr. et al. Gr. Num 251816, November 23, 2021. This is the 62nd case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine Bar Examinations. Follow for more. Don't miss out. Hit that subscribe button and get notified about our latest content. Elevate your legal knowledge today. A psychologist, Florentina Caoyong Sobrejuanite-FLORES, faced a career-defining challenge. With ambitions to be recognized as a professional psychologist without undergoing the licensure exam, as permitted by the Philippine Psychology Act of 2009, RA number 129, Florentina's journey hit a significant roadblock. The Professional Regulation Commission, PRC, and the Board of Psychology set forth a requirement. Professionals in her field needed to complete at least 100 hours of updating workshops and training programs. Florentina believed she met all the necessary criteria, except, according to the PRC, she lacked sufficient proof of work experience and the required professional education updates. Her appeal to the PRC was denied, a decision later affirmed by the Court of Appeals. Left with no other recourse, Florentina took her fight to the highest court in the land, the Philippine Supreme Court. The crux of the matter lay in whether the additional requirement of 100 hours of professional updating was constitutional. The Supreme Court, in a landmark decision, ruled in favor of the PRC. It stated that the requirement was within the bounds of the law, aimed at ensuring the competence of practicing psychologists, thus protecting the public interest. This decision underscored the state's authority to regulate professions and ensure that individuals offering psychological services are well trained and up to date with current practices. Dispositive portion. The petition was denied, and the Court of Appeals decision dated May 21, 2019, in CAG-RSP. Num 150841 was affirmed. The provision of Section 16C of the IRR of RA Num 129 was declared constitutional. Important doctrines: police power and regulation of professions. The state has the authority to regulate professions, to protect the public interest, even if such regulation might interfere with personal liberties. The regulation through licensure examinations and professional requirements is a valid exercise of the state's police power. Subordinate legislation. Administrative bodies are permitted to fill in details of a statute by promulgating rules and regulations to effectively implement the law's policies, provided these regulations do not exceed the bounds of the law. Equal Protection Clause. Administrative regulations that differentiate among persons must be reasonable, not arbitrary, and must serve a legitimate government interest. Regulations that create distinctions based on substantial differences in qualifications and experience to fulfill a public purpose do not violate the Equal Protection Clause. Don't miss out. Hit that subscribe button and get notified about our latest content. Elevate your legal knowledge today. The moral of the story is clear. Continuous learning and professional development are not just bureaucratic hurdles, but essential elements in ensuring the highest standards of practice in professions that deeply impact people's lives. Disclaimer: this story is a simplified narration based on a legal case for educational purposes. It is not a substitute for legal advice, nor is it infallible. No financial details were involved in the case's disposition.